welcome to this special show, and I'm in conversation with one of India's topmost legal eagles, Mukesh Butani, Managing Partner, BMR Legal. Thank you so much, sir, for joining us. I would like to begin and ask you on a question, or a crucial question that perhaps everybody is wanting to know, is that, when we talk about ever since the new government has come in, time and again, they have definitely, tried to soothe the nerves in terms of saying that they will be bringing in some consistency in the tax policies and the regime. They will try to address the concerns that have been raised lately as far as the entire issues that have really come and staring at India and its tax policies. But do you think really that the government is being able to walk the talk with regard to the tax policy regime?
I think a lot has changed in the last 18 months in the operating environment. Before I get to really answer your question, let me say that when you're talking about a perceptible change in the environment, you're looking at changes at various levels. For example, you're looking at a change in the stance insofar as tax policy is concerned. So, for example, whether you should reduce the corporate tax rate, whether you should take away the exemptions, whether you should introduce GST or not, these are all tax policy changes. Thereafter comes the issue on how do you go about administering the tax policy. How do tax officials treat the taxpayer? Do they treat the taxpayer as a customer? What kind of policy do they follow when it comes to recovery of taxes? And how do they actually interpret the intent of the law which is passed by the parliament? And the third, of course, the more important one is also, if there is a difference of view between the tax administration and the taxpayer, how do the judicial forums resolve the issue? So I think when you're looking at a tax policy, you need to look at all three aspects. I would like to believe that there has been a perceptible change in all the three areas. We saw in 2015, early this year, when the government presented its first budget, the tax policy stance was clearly evident, whether it's got to do with their resolve to legislate the GST law, or it's got to do with their resolve to reduce the corporate tax rate. Insofar as tax administration is concerned, I think these are deep-rooted reforms. They are not going to come overnight. But I certainly see a change in the environment at the ground level in terms of how field officers treat the taxpayer. And last is the judiciary. Again, these are deep-rooted reforms, because many of the aspects with respect to judicial forums by way of High Court and Supreme Court are beyond the realm of the Ministry of Finance. They fall in the Ministry of Law. So how do we go about disposing cases in the High Court and the Supreme Court? Pendency of cases in the High Court and Supreme Court, the challenge goes much beyond the tax laws. But to your question, has there been a change in the last 18 months? I would say yes. The degree of change varies. Which basket are you looking at it? I think we will need to wait for some time to see a more positive change coming in the environment.
So let me, bring our conversation to a very crucial topic that the entire country is looking into, the global and the domestic industry also, which is with regard to the biggest tax reform, the GST reform. What would you recommend is that India should be careful of in terms of the rate parameter to begin with?
My personal view is that you're better off keeping the rates lower. However, if you look at it from a government standpoint, it's a double whammy for the central government. On one hand, they have to give commitments to the state government that they will make good the loss of revenues for the state government to transition into the GST system. And on the other hand, they are also facing a continuing challenge on how to manage their fiscal deficit targets. So I think it's a tightrope walk for the government. I think that the central government wants to err on the side of caution, keep the rates on the higher side, let the GST law settle down. It's going to take 2 to 3 years for the law to settle down. I don't think that we have any scientific basis to be able to come to what is the rate. But yes, if you look at internationally also, the rates vary. Today, even in continental Europe, the rates are hovering between 19 to 20%. So I don't think that there is any quick scientific basis for us to be able to come to this magical figure as to what should be the rate of GST. But I would imagine that it would be north of 18% and it would be south of 25%. I think somewhere in the middle.
As an expert, what are your views on the three conditions that have been placed by the opposition for the GST bill to pass through?
Well, let's look at all the conditions. First is this 1% levy, which will benefit the states which are really the manufacturing states, which essentially is Maharashtra, Gujarat, Karnataka, and Haryana. I think this 1% levy is an issue where even businesses were not happy with that, because this was an extra cost and it was regressive even from a business standpoint. I think the central government put it as a part of the compromise formula. Now the select panel is saying that this 1% should be dropped. I don't think it's a big deal. I think it's a business call that the government has to take. Now let's look at having the 18% rate, or whatever is the eventual rate, being ascribed in the constitutional amendment. Now this is a bit unusual, and I'll tell you the reason why. The Constitution, you cannot go for a constitutional amendment. So let's say, for instance, we settle at the 18% rate, and let's assume that 18% is written in the Constitution. What if it at a later stage, the government wants to raise the rate of GST? Does it mean that it has to carry out another constitutional amendment? The answer is yes. We are seeing the challenges that we have today in the federal system that we have in our country as to carry out a constitutional amendment. Why should that be ascribed in the Constitution? And if I accept that argument, then why not rates of income tax? Why do we have finance bill every year prescribing the rate of corporate tax? We should put that also in the Constitution. So I think that's, in my view, an impractical and unworkable proposition that has been put forth by the select panel. I think the third issue is neither here nor there as to what kind of empowerment do the states have with respect to settlement of dispute. I don't think that the GST law should be held back only because of that. If the Prime Minister of the country believes that we want to follow cooperative federalism as a model for India, then obviously the disputes that arise between the state and the central government will have to be settled within a forum where there is equal representation from both the sides. So I think that point is neither here nor there. I don't think that should be the basis to hold back the GST law.
Other important change that we are seeing, and something that was announced in the last budget, was with regard to the corporate tax to be rationalized and brought down. And at the same time, we've just seen a draft paper as far as the phasing out of the exemptions are concerned. Take us through, in your view, as to how would it really change or bring a paradigm change really for the corporate India?
Well, I think, let's step back a little bit. Tax exemptions and tax holidays have been an integral part of the tax policy in order for us to attract investment. And it was far more visible in the post-economic reforms era, post-1991. Now, there are some exemptions which have been extended, or tax holidays which have been extended over a period of time, whether that is for a particular geography, location, or that's for a particular activity, say telecom, oil and gas, power generation, distribution, roads, ports, so on and so forth. And the third form of exemption is by way of accelerated amortization to promote investment. And some of these were brought about in the law only in the last 2 to 3 years, so that there is pickup of investment and capital investment activity in certain areas. All of these put together gives the government an annual statement as to what is the give away by the government on an annual basis, which means that our tax rate, which is roughly around 32 to 33%, including the surcharge and cess, is compared with what is the effective tax rate of the country. And I think there is a gap between that. So what the finance minister said last year, he agrees that the corporate tax rate has to be brought down, but in tandem, he has to take up the effective tax rates as well, so somewhere they merge. The proposal which has been now put out by the Ministry of Finance lists down comprehensively all these forms of exemptions. And what it says really is that exemptions that have a sunset clause, say for example, one sector enjoys tax holiday and it is ascribed in the statute that that tax holiday expires, say, on March 31, 2016 or 2017, will not be extended. The second thing that it deals with is that where there is no sunset clause, we would like that particular industry or that particular special economic zone, so on and so forth, to start operations and become functional by March 31, 2017. Right? Now, there is clearly an approach by the government that we need to take away all of these exemptions. But I think that approach has to be, in my view, delicately balanced with an important question: what impact, if any, it has on investments. Let me give you an example. Let's say, for instance, SEZs, which are not notified before March 31, 2017, will not be entitled to SEZ holiday. Now, is that fair? If I'm an entrepreneur, I have an SEZ on my drawing board in 2013 and 14 in order to make it operational by 2017. How fair is it that in 2015 I'm hearing that if for any reason my SEZ does not get notified by 17, I will lose the exemption? And for all you know, many of these large SEZs may not get notified by that date. So I think the government needs to now tread very carefully here, whether it wants to take away all the exemptions in the manner it has been identified in the proposal, or it wants to have a calibrated approach. My suggestion is that there should be a calibrated approach, because you're not bringing down the corporate tax rate from 30 to 25% immediately. You're doing it over a phased manner over a 4 to 5 year period. Similarly, you should look at all of these exemptions. You should look at the economics of these exemptions. You should look away, on one hand, what you're giving up and what you're getting out of it. Maybe you're able to generate employment, which is required the most. Maybe you're able to permit greater degree of capital investment in plant and machinery in a particular sector. One of the exemptions that is being taken away is R&D expenditure for pharmaceutical industry. Now, is that something that we can afford? Will that in any manner cause entrepreneurs in the pharmaceutical industry to bring down their R&D, particularly given the fact that many large Indian companies are now looking global from an R&D, from a pharmaceutical industry standpoint, where they need greater degree of R&D. So I think that it needs to be looked into, but bear in mind, these are merely proposals. They have been put it out for public comment. I have no doubt in my mind that the government will consider, debate all of this and then take a decision.
Sure, sir. But now that brings me to the question that if we look at the entire landscape with regard to India trying to attract investments, tax is one part of it, and consistency in the tax regime is one part of it. But other than that, you have your FDI policy coming into place. We just last month we heard a slew of reforms that the government had considered. It's got a cabinet nod as well. We are also looking at several aspects, whether ease of doing business, etc. You have the Prime Minister going into different countries trying to really put forth and sell the India story. What are the investors talking about currently, and how are they viewing India at this point in time? What is your sense?
I think insofar as the first part is concerned, clearly there is a very positive sentiment insofar as India as an investment destination is concerned. Now, whether that is being borne out by improvement in India's ranking on ease of doing business, which is marginal, but certainly it has reversed the trend, or it is borne out by the fact that the world economy is slowing down, China is slowing down, and then the world is not left with any option but to invest in India. But I think the demand projections for India, particularly from a domestic standpoint, is also showing visible increase. So if you look at the last 2 to 3 month trends, and if you look at the consumer electronics, or you look at the FMCG sector, or you look at motor cars, all of these are showing an upward trend. So I think, we've got to a stage where we cannot, no foreign investor can afford to turn a blind eye insofar as India is concerned. Now, having said that, what kind of policies can we have in order for us to continue to grow and attract foreign investment? I think that, in my view, is a bigger and an important question. Let me just give you some statistic. The United Nations Conference on Trade and Investment released a report in 2015, and the report talks about the fact that 80% of the business transacted by multinationals are between related parties, largely in emerging economies. 40% of trade in India, international trade in India, imports and exports, are between related parties, and these are largely multinationals. Now, we have the world being focused on this base erosion and profit shifting project as a part of the G20 initiative, which India is a part of. Now, the G20 may believe in its larger wisdom that countries need to collect their fair share of taxes, but I think emerging economies such as India need to look at it very differently. It needs to look at dual objective. How do I collect my fair share of taxes and also continue to retain myself as an attractive investor country? Brazil and Germany had a treaty which was cancelled. As a result of that, Germans are reluctant now to invest in Brazil. So now the challenge for countries like India and challenge for us is, how do we make sure that we have a sensible network of tax treaties, a network of bilateral investment treaties, such that the investments of these multinationals are protected? So you cannot look at India being an attractive investment on an isolated basis. You need to look at balancing out investment with collection of fair taxes, supported by international conventions by way of investment and tax treaties. And it's only if you're able to balance out all these three that you will be able to come to a conclusion that yes, we have arrived as a destination, and this is on a sustainable basis, and we are not looking at an outlook of 3 to 5 years, but we're looking at 15 to 25 years insofar as attracting investment is concerned.
So that brings me to a follow-up question. It will be a two-part question. One, of course, as you pointed out about the treaties and how the government will have to really look into it. We are already, talking about the Mauritius treaty that the government is renegotiating. India really seeking that the capital gains should be taxed. Do you think that will, and as it has in the past, will spook investors? That's number one. And the second question really is that issues such as Vodafone or MAT that we saw the controversy, are those really behind us?
Well, let me now, let me touch on the India-Mauritius treaty question that you raised. I think there are two ways to look at it. One is it's a bilateral treaty negotiation between India and Mauritius, and India and Mauritius have to come on table and discuss. I think both the sides know what the issues are. India is insisting on a strong limitation of benefits clause. Mauritius feels that if there is a strong limitation on benefits clause, then a whole lot of investment will get diverted. I think the writing is on the wall. In the BEPS era, all of these treaties are likely to have a standard limitation of benefits clause. So I think sooner than later, India and Mauritius will amend the treaty and there would be a limitation of benefits clause. I think the question at that point in time would be, are you grandfathering the past investments? If I look into the debates on India-Mauritius treaty, which was left by the earlier government, it did give a grandfathering clause, but it did not come out with adequate level of clarity. How will the grandfathering clause apply? Assuming that there is a sensible grandfathering clause, then all the investments that have been made in the past should ideally be protected, and it's only on a go-forward basis that the investors will be mindful of using treaties, countries, more in a different manner in light of the limitation of benefits clause. So that's on the India-Mauritius treaty. Your other question was, is the FII MAT issue and Vodafone behind? I think the FII MAT issue is behind us, and I think that's another instance of how the government decided to intervene in an issue. Now, from a tax policy standpoint, the government could have easily kept quiet and said, let the battle continue. This is between the administration and the taxpayer. We have a judicial system which is fair, reasonable, rule of law prevails in our judiciary system. Let the courts decide. But what could have happened if they had left it? It could have taken perhaps 5 years, 10 years, 15 years, and the damage would already have been done. So I think there the government intervened. It had the Law Commission submit a report. Though the Commission's findings are not binding on the government, it accepted that report. When the matter came up in the Supreme Court, the law officer said that the government has already taken a policy decision on this, and the policy decision is that the law is likely to be amended in 2016 to take away the clutter which caused the confusion whether MAT should be levied on FII or not. Insofar as Vodafone is concerned, it's complex. But as I hear from the news that the government has made an offer for an out-of-court settlement, I just hope it gets settled fast, and it's not just bringing certainty to Vodafone, but it brings certainty to all the other taxpayers who are getting impacted because of the retrospective law that came after the Vodafone judgment.
Last but not the least, we've already seen that the government outlined the fact that the next budget, which is just a few months away, is also going to stress on bringing in more tax reforms and tax clarity. And if, as a tax expert in the country, what would you recommend that the government should be focusing on?
Well, I think there are 2-3 aspects. As you know, just about 15 days back, the government set up a committee under former Justice of Delhi High Court, Justice Ishwar, which has 10 members as well, which are expected to look into those aspects of the law which bring about interpretative issues and which will help the government avoid disputes. I think there is a lot that the government needs to do to speed up the dispute resolution. Now, to speed up the dispute resolution, one aspect is that the government can consider having more benches of the tribunal, dedicated tax benches for high courts. We already have a dedicated tax bench in the Supreme Court. Actually lay down targets for disposal so that the disposal is faster. Because you cannot do anything to matters which are already before a court of law. I think the second aspect that the government can look into, again from a medium to long-term perspective, because you cannot achieve it in the budget, is trying to strengthen the mechanisms to avoid disputes. Most of the disputes that we see in India arise out of interpretation, which under the Indian system is more principle-based rather than rule-based. So I think if the government comes out with a host of subordinate legislations by way of rules or by way of administrative circulars or by way of interpretative memos, I think it can lead to a lot of reduction in disputes in the future as well. So I think host of measures, I think there are several committees that have successfully given recommendations. All tax experts are also of the same view. And the last thing that it can do is, strengthen the mechanism to give, rulings, so we have the concept of advanced ruling, but that's restricted only to certain class of taxpayers. It should be made much more broad-based. There is already a proposal to set up benches, additional benches in Mumbai and Delhi, but I think some of those aspects will bring greater degree of certainty, clarity, and in my view, also soothe the nerves of taxpayers who feel extremely nervous facing the tax man.
All right, sir. Thank you so much. Once again, appreciate you joining us and sharing your valuable insights.
Thank you.
Well, that's all we have time for in this show. Thank you so much for watching.